This video has been given to you to help you guide, or help guide you through a joint tenancy trust plan. The video will cover both the last will and testament and the joint tenancy trust that you have selected for your estate plan. The joint tenancy trust has as its primary purpose to protect each of you during your lifetimes, your joint lifetimes, protect the survivor of you, and then go on as you've directed to various beneficiaries, primarily children. It also will avoid probate if your assets are funded to the trust, which we'll touch upon a little bit as we go through the video with you. Maury's going to start out with the last will and testament. So if you will look into your pack of information, you'll find your joint tenancy trust and your last will and testament. There should be a red pin there for you to use and kind of follow through. We're going to be giving you some instructions as we go through. Please use that red pen to make notes if you need to. Then you can contact us and tell us what you found, or if you come in for a read-through appointment, you'll have your notes made. So with that, Maury?
Okay, before I get into the documents, another initial comment. Roy mentioned in the beginning that one of the purposes is to protect you with respect to the assets that are funded. I just want to make it clear that we're not talking about protection from creditors or anything like that. What we're talking about is making sure that there's somebody there to provide for the distribution of your assets should you become incapacitated or pass away. So the documents are there to kind of guide the trustee as to how your assets should be handled and distributed. But you do not get creditor protection from your own creditors by putting assets into this trust. Take out in your packet the document that's entitled Last Will and Testament, and it should say of, and then your name should appear. You can feel free to pause the video if you need more time to get it, but I'm just going to keep going through. At the top of that document, it should say Last Will and Testament of, and then your name should appear. Make sure we've got your name correct. If you decided to use a middle initial, make sure that is there. In the opening paragraph, it should say I, your name should appear, your address should appear, and it should say you're making this your will and you're revoking all prior wills and codicils. And a codicil is just a word for an amendment to your will. Article 1 is next, and that talks about interment. Make sure that we've got that section correct. So go ahead and read through that. If you elected cremation in that section, make sure we've said that right. Make sure we've said how you want to have your ashes handled. If you want burial, make sure that we've got that in there. If you've decided to donate your body to science, make sure we've gotten that wording in there. Whatever it is that you told us to do, make sure it's in that interment section.
The cemetery spelled correctly, that sort of thing.
Correct.
Make sure you're checking all of that.
Article 2 is the personal property article. If you've elected to have personal property given to, for example, all of it to your spouse and then the balance to your children, we will have spelled that out there, and that's usually where we put that if you haven't given us any specific instructions. So make sure in that paragraph your spouse's name appears first and it's spelled correctly. And then if you've decided to leave all of your personal assets or your personal property, household goods, things like that to your children's name should appear next. And typically then what we say is in this paragraph, if a child predeceases you, leave that property to their descendants on a per stirpes basis. And per stirpes just means follow the bloodline of your children or grandchildren. Usually though, with that personal property, if you're electing it to go to your children and your child would predecease you and leave a share to their children, your children are going to decide which specific assets make up the grandchild share, so long as they get an equal share is what we're after here. If you'd like your personal property handled differently, just let us know.
Now, there is a paragraph there that says the personal property article does not include these following types of assets. Where do those get handled?
Well, if you look in there, you're going to find that paragraph, and it's usually the second paragraph within Article 2, and it talks about things that are not included in the personal property, like money, securities like stocks, bonds, choses in action, which is really a right to bring a lawsuit, and other various things. Those things we're not deeming tangible personal property, which is covered by this article. Instead, we're saying those things get handled by the rest and residue clause and are passed in accordance with that paragraph, which is going to be next. That is Article 3, in fact. Rest and residue is what it should be titled. And that's where you're saying where everything else you have. So you've already dealt with the personal effects that you have, the tangible personal property. everything else that you might have. So if for some reason you don't have in your trust a piece of real estate, if you have any stocks or bonds or money or anything else, you're saying that passes with this. And we've made your joint tenancy trust the primary beneficiary under your will. Now keep in mind, if you followed our instructions and you've gotten all of your assets into your trust, there really shouldn't be anything that's being covered by this Article 3 because everything is already in trust. And that's your goal, is to help avoid the probate process, which is the court process of administering your estate and validating your will. You want to avoid that process and the expense and time associated therewith and the publicity of that process, and just go ahead and get everything in your trust now. And as you acquire assets during your lifetime, you'll make sure those are in your trust. That way this Article 3 really doesn't come into play, but it's here as a safety net just in case you have assets that are outside of your trust. This says, trust or executor, pick those assets up and give them to the trustee as the primary beneficiary. Article 4 next is a survivor article. It basically just says that people have to survive you by 30 days to inherit under your will. Article 5, at least in my document, your articles may be just a little bit differently numbered depending on what you told us you wanted, but the next one is the executor appointment and powers. Go ahead and read through that paragraph, the opening paragraph there, and make sure that we've got your executor's names correct. Usually it's going to be spouse first and then whoever you've selected to follow your spouse. Make sure we've got addresses correct, that everyone's in the right order, and you don't see any errors there. One of the things we've said in that paragraph is that you're allowed to administer this estate independently, so that you don't have to, if for some reason you have to go through a probate estate, you don't have to go through the judge for every little thing. So we've kind of built in some flexibility there for your executor. Following that, we have several powers that your executor has. I'm not going to read through each one of these. Basically what we've done is tried to give your executor the power to do anything that he or she might need to do to administer your estate, settle your claims, pay your debts and expenses, that kind of thing. So that goes through a laundry list of numbered items. And then we've got a date. You'll be filling in that date when you come in for signing, and then your name should appear. Make sure that we've spelled your name correct again. And then down there, below that, we're certifying by witnesses. Again, your name should appear. Make sure your name's spelled correctly. Your witnesses will then sign when you're in the room with us signing, and then there should be a notary block where the will be notarized after your signature. Again, make sure your name is spelled correctly in that paragraph.
So Maury, let me ask you, if I have a joint tenancy trust and I have all of my assets, real estate and personal property titled to that trust, I won't have an executor.
Correct.
And I won't have any of these powers being operated under.
Correct. Yeah, so that's the point, is if you've gotten this trust, you want to avoid the probate process if at all possible, and if you've done that well, you won't need to worry about your will. Your will be filed in the courthouse at your death, which is required by state law, but beyond that, that's all that'll happen. There shouldn't be any assets to be administered by the court or the judge, none of the probate process or expense or time associated therewith. Everything will just follow along with what your trust says. And that's a good time to now talk about your trust. If Roy mentioned you have a red pen, if you have any questions or changes you want to make to the will, go ahead and note them on there and you can bring them in and talk to us, or just give us a call and tell us what they are if they're minor changes. The next document I want to talk through with you is your joint tenancy revocable trust. So pull that document out of your packet and look for your names at the top, followed by the words joint tenancy revocable trust. Now in this one again, in the opening line there that's in bold, I want you to make sure that we spelled your names correctly, both first and last names. If you've opted to use middle initials, make sure those are there as well. And then we go into an opening paragraph. And in that opening paragraph, we'll again have your names, and you're saying that you're transferring a certain amount of property to yourself, and any assets in your trust are going to be administered in accordance with the trust provision. So again, make sure your names are correct. Article 1 is just some introductory things that we're talking about. Article 1.1, for example, is telling us who your family is. Make sure we've identified everybody correctly by name and who they are. For example, if it says somebody, the wife, let's make sure it's not the husband listed there. So double check that we're doing our job correctly on that one. We will also have named your kids, your children, if in fact you are providing for them, and make sure their names are spelled out there. Article 1.2 is the actual name of your trust, and that's what you'll be using on all of your accounts and things that are titled in the name of your trust. Now there'll be a date that's going to be blank there. You're going to be filling that in at your time of signing, so make sure when we get to signing we've got that filled in correctly for you. Article 1.3 talks about what happens when you put things into this trust, and this is pretty important if you have separate property that you guys are bringing into this trust together. That paragraph is basically saying that anything you put in this trust becomes marital joint property. So if you intend for something to not be marital, please make us aware of that so we can talk you through that and how to adjust the trust accordingly. But otherwise, anything you put in here becomes marital property and it will be deemed marital even if it was separate before it came in. Article 2 talks about your right to amend and revoke the trust. And Article 2.1a says that while you're both living incompetent, you can amend this trust by an instrument signed by both of you and referring to the instrument delivered to the trustee. So you guys are free to amend the trust at any time you want if you guys both sign it. 2.1b talks about the right to revoke your trust, and it says again, while you're both alive and competent, you can revoke this instrument signed by either one of you. So that's a little different from an amendment where both of you have to sign it. If you're going to revoke it, either one of you can sign that document to revoke your trust, and at that point, all the property in the trust is going to be distributed jointly to the two of you as marital property. Article 2.2 talks about what happens after the death or incapacity of one of you. And it says, should one of you become incompetent, and that's referred to as the incompetent spouse, the other one may amend or revoke the trust at any time by written instrument signed by the competent person, referring to this instrument. So that's how you can do it, via amend or revoke. The competent settlor can do that. Now, if you do that, property is going to be distributed jointly, but not everyone has selected or elected to do or have the ability to amend this by the competent person or revoke it by the competent person. There are times when you might decide that if one of you becomes incapacitated or dies, that you don't want the survivor to be able to amend that, and that's what Roy's going to talk about now.
On several occasions, I've talked to clients to discuss this very provision as to whether or not, if something happens to one of you, incompetency or death, does the survivor or the community spouse, the spouse who is fully competent, should they have the ability to amend, revoke, change the trust in any way they want on their own? And there are clients who say, no, we really don't want that. The feeling being, we made the decision while we were both living, while we were both competent, this is what we want, and we don't want it changed by just one of us acting. And better stated perhaps is, we don't want to have the risk of being manipulated into changing the trust by someone that might come into our lives. Very sound decision. There certainly isn't a right or wrong way of doing this. It's really a case-by-case situation. So make sure we're stating how the two of you feel. We want the one of us who is able to go ahead and make an amendment or revoke or change the trust in some way, or you don't. But we want to make sure that we have it correct, that it's a major provision in the trust.
It is significant, and again, you need to make sure you don't gloss over that. What I kind of explained a minute ago was giving the spouse maximum flexibility to amend or revoke if one of you becomes incapacitated or dies, and what Roy just explained is that provision might say you're locked in stone at that point. So make sure we've got that spelled out correctly.
The trust becomes irrevocable.
Right.
Upon the death or incompetency of one of the spouses. Right. Now, let's go on to Article 3. And if you're at the proper spot in the trust, it's going to say administration of trust during joint lifetime. So you're both okay at 3.1, and as long as you're both okay, you're not going to notice any change in your lifestyle, so to speak, because of this trust. You can use income, you can use principal in any fashion that you desire, any fashion that you were doing prior to the time you entered into the trust. If one of you is incompetent, and this is an irrevocable type of situation where one of you is incompetent, so now the trust is irrevocable, but one of you who is acting outside, you're the community spouse, you can direct the trustee to make any payments that you so desire to maintain your accustomed manner of living. So food, clothing, housing, groceries, all of those expenses that are typical expenses you can continue to draw out for. As as long as both of us are in consummate, the trustee may pay to each of us income and principal, but once something has happened to one of you, then it's going to be a custom manner of living standard. Then accumulation of excess income. If there's income that's not paid out, for some reason you have money that you don't need, it's labeled income and you want it to be invested, it's simply added to principal. So that's kind of a bookkeeping instruction there. Determination of incompetency, I kind of want to walk through this with you. Either of us shall be incompetent if that person is under a legal disability or is unable to give prompt and intelligent consideration to financial affairs. The determination of a person's liability shall be made in writing, signed by that person's personal physician, and if that person's spouse is then living, and able to so act by the spouse and delivered to the trustee. So for you to be determined incompetent, and thus in this particular situation, making the trust irrevocable, it has to be your attending physician and your spouse, if your spouse is capable, signing a document that states this. It's not a court action.
Right.
It's not that you're going to be taken into court and publicly be declared incompetent. So important provisions there, make sure they're stating what you so desire.
And again, Roy pointed out that if you're deemed incapacitated or incompetent, this trust may become irrevocable. Now that's if you've elected to do the restricted sort of trust. If on the other hand, you've elected to give your spouse maximum flexibility, and you're not worried about things being changed or amended or someone coming in and taking assets, then you've elected to do the alternate way, which is if one of you becomes incapacitated, then the other one is free to amend or revoke the document.
And use income and principal as they desire.
And exactly, use income and principal in any way you direct. Versus if you're a restricted sort of trust, we've changed that to say you can only use income and principal for those kind of needs of living sort of things.
And then going on to what we label survivor's trust, you'll find that part of the document. You'll see there's a mandatory payment of income. What you're saying is one of you is deceased, the other is surviving, and you're okay so far as competency. Beginning with the death of a deceased spouse, the trustee shall pay. That's a very important word, shall. There's no choice on the trustee here. Income is going to be paid out to the survivor. On the death of a surviving spouse, any accrued or unpaid income shall be added to principal. So as long as you are the surviving spouse and you're competent, the income is going to continue to come to you. Discretionary payment of principal. The trustee may pay to the surviving spouse as much of the principal as the trustee from time to time considers necessary for the health, maintenance, and reasonable support, reasonable comfort, best interest of the surviving spouse. So you have access in the irrevocable situation for all of these things, health, maintenance, reasonable comfort, best interest of the surviving spouse. So keep that in mind. And more, I think, in the, whether it doesn't become irrevocable, they, again, full use of income and principal. So
That's right.
A little bit of a difference.
That's right. So yeah, you're right. If you're not in that restricted trust, it's going to say something along the lines of the surviving spouse can direct all the money to come out and be used for whatever the spouse wants.
Now, the surviving spouse in the irrevocable situation has no right to simply withdraw principal, as Maury just indicated that in the non-irrevocable, the revocable, they can draw out principal anytime they want, in unlimited amounts.
Right.
Power of appointment, if you're the surviving spouse in an irrevocable situation, you don't have a power of appointment. Now, a lot of clients will look at me and say, well, what is a power of appointment anyway? What a power of appointment allows you to do is write a will, for example, and leave the trust at your death to whomever you like. Well, if the trust is irrevocable, it already states within the document where it's going to go at your death if you're the surviving spouse. It's going to go to your children, grandchildren if a child's died before you, those typical provisions that we're going to cover here in just a minute. Distribution on termination on the death of the surviving spouse, the trustee shall distribute the survivor's trust as follows. And again, we need you to look at this closely to make sure we have it the way you want. Gifts of tangible personal property. The trustee shall make gifts of tangible personal property as follows. Number one, by written direction. Now, Maury and I both believe that written direction in the type of plan that we've constructed for you comes in that last will and testament, where you're talking about personal property. Remember Maury reviewing that with you. You're giving instructions as to how that personal property is going, and you're saying to the trustee, look at that and I want you to follow that. Now, if there's something that isn't covered under the will, then you're saying it simply goes to your children or other beneficiaries as you may have selected. So give careful consideration to that item number 1 and number 2 under gifts of tangible personal property. Make sure that it states where you want things to go. And then the remaining trust property, that would be, as Maury said, everything other than personal property. The trustee shall allocate the then trust estate in shares of equal value for our then living children. That's typically what we see. That doesn't mean that's what your document reads. It should read the way you want it. Maybe you wanted 60% to one child and 40% to another, or maybe you wanted the house to go to one child and the other assets to all the children. Make sure that remaining trust property paragraph reads the way you want, and advise us, or better yet, call Melissa if you have a change that you can make over the phone.
So once you get through how you're distributing out your personal property and then how you allocate the balance of your trust, as Roy just mentioned, then let's assume that you have children that you're leaving shares to. The next article talks about your children's trust and how they're going to be treated. And basically what I'd like you to do is read through that whole section 6. It's only 4 or 5 paragraphs long, and make sure that we spelled out how exactly you want property distributed to your children. For example, you might have decided our children are old enough right now, they don't have any financial issues or marital issues, we're fine just giving a full distribution to our child or children immediately at our deaths. So then at that point, the trustee would be paying the debts and expenses and then distributing to your children in the fashion that you've so chosen. Maybe that's equally, maybe that's 60-40 like Roy's saying, or whatever way you've elected. A lot of you though might have children that are either underage or under a certain age that you really don't want them to inherit their property, or maybe they've got other difficulties, financial or other, in their lives, so that you're not really ready to give them an immediate rights to their share. So if you've told us about that, make sure we've got the age restrictions that you thought appropriate, or other restrictions that you thought appropriate in this section about distributions to your children. We've got sections in there, for example, if you've got payments to your children that have not reached the age or ages that you want, that the trustee can pay out to them the income and principal as the trustee thinks is necessary for their health, education, maintenance, support, those kinds of things. So it's not as if your trustee is going to be completely restricted as to what they can and can't do with the trust. They're authorized to pay out for certain things as you've directed us. And if you have not, again, make sure as you're reading through that you're comfortable with what we've put in there for distributions to your children. There is assuming that you want your children to have the immediate right to withdraw their share, we've also got a power of appointment provision, which as Roy described, they can write their own will saying where their share goes upon their death if they haven't yet distributed or taken their share out. There's going to be restrictions on that. If you've selected an age that they're restricted, then they're going to be restricted by that age in doing a power of appointment as well. But that is in there if you've given your children the rights to their share. The last part of that section deals with distributions of your child's share upon their death, and we will have covered what to do with the child's share if they die after they've already got a trust created for them. And usually what we'll say is, unless you tell us otherwise, their share is going to be going down to their descendants on a per stirpes fashion, so just look for their children, and if their children are deceased, look for their children. So basically just following the bloodline. And if they have no descendants, we'll have covered that as well in the document, which is basically taking it up and giving it to your descendants on a per stirpes fashion, unless you've told us other instructions, in which case we'll have those filled in there. Article 7 is next, and that covers what to do with for example, grandchild share. We've got an age filled in here where it says that your grandchild will have the right to take their distribution at a certain age, which you've told us. Make sure the age that we filled in there is correct. And again, if there's a share created, for example, a grandchild, and they're not at that age, the trustee is going to be authorized to pay income and principal as may be necessary for the support, maintenance, education of that person. And that leads us into trustee succession, which is going to be Roy again.
Okay. Very important clause here, very important section or article, trustee succession. All of these things that we've been talking about, this is the way I want my trust to be handled, this is how I want my spouse to be treated, this is how I want my children or grandchildren to be treated, that's going to be carried out in large part by the trustee. Usually in a husband and wife situation, you'll start out being co-trustees of the trust. And that's almost universal, I would think. But what happens if something goes wrong with one of you? Death, incompetency, you're just not able to do it for whatever reason. Sometimes the document will state, well, the spouse that's okay mentally is going to go ahead and continue serving as trustee. Sometimes the document will say, well, the spouse that's okay can continue to serve as trustee, but we want this child to be serving with him or her as co-trustee. Sometimes it will say, no, the spouse can't serve as trustee. In any event, we're going to name this child to do it, or this person to do it, or this bank to do it. It is kind of what fits your situation. Make sure what we discussed with you, what you told us, is reflected in that section. There's going to be some named trustees in the order that you gave us. Make sure you look at those names, they're spelled correctly, the addresses are given correctly, and typically we will end up saying if none of the named persons are able to serve, then a corporation is appointed, a bank or a trust company is appointed. You don't have to decide on the bank or trust company now. If it ever comes to that, your then income beneficiaries will make that election or make that appointment. So again, very important clause, you're naming the individual or the entity that's going to carry out the instructions that you've given with regard to your joint trust. The next section that you're going to come to is entitled Trustee Actions. And what you're giving in this section, this is you talking to the trustee. These are actions I authorize you to take, or these are actions I want you to take. And they're spelled out for